Start. Per contra, learned AGA submitted that it is well settled that the first information report need not be an encyclopedia. Thereafter, even if PW1, the informant had not stated in the FIR that the deceased went out and was shot when he was on the road. The substratum of the prosecution story that the deceased was shot by the appellant remaining intact and the medical evidence indicated that the appellant died on account ante-mortem gunshot injury. The prosecution story is not liable to be disbelieved merely because all the details of the manner in which the incident occurred were neither disclosed in the FIR nor in the statement recorded under Section 161 CRPC. He further submits that the site plan prepared by the investigation officer refers to the spot as the place where the injured was found lying, which means that the deceased was not dead at the spot. Thus, the story that he was rushed to the hospital and on return therefrom the FIR was lodged appears natural and not contrived. Otherwise, also, when a person is injured, even if he may be dead, there is always an attempt to rush him to the hospital to save him, even if there is no possibility of him surviving the injury. Hence, the statement of PW1 that the deceased was rushed to the hospital does not at all dents the reliability of PW1's testimony. Learned AGA further submits that assuming that in the seizure memo prepared on 28/6/1998, case crime number section 302 IPC is mentioned at the top, that by itself is not sufficient to discard the first information report as anti-timed or bogus, because it could be possible that the seizure memo may have been completed afterwards. He further submits that assuming that there may be some lapses in the investigation and due care was not taken while filing the papers, that by itself is not a ground to discard the ocular testimony of PW1, whose presence in the house has not been questioned and no suggestion has been put to PW1 that he was not present in the house at the time of the incident. He further submits that the testimony of PW1 is reliable and the conviction recorded the testimony of PW1 finds corroboration from the medical report. Hence, he prayed that the appeal be dismissed. Having noticed the rival submissions, before we proceed to analyze the weight of the respective submissions, it would be appropriate to notice the testimony of the prosecution witnesses in brief. PW1 Harish Chandra, in his examination in chief on 4/6/2001, stated that the accused Satya Prakash and Kanhaiya are real brothers. The accused is cousin of Satya Prakash. Satya Prakash is married to PW1's wife, niece, as Satya Prakash used to ill-treat his wife. She left her matrimonial home and went to her parents' house to have her back. Satya Prakash used to pressurize PW1. For that reason, Satya Prakash had a grudge against PW1 and his family. In respect of the incident in his examination in chief, PW1 stated that on 28/6/1998 at about 9 p.m., he and the deceased were sitting in their veranda on a wooden cot when all the four accused came with country-made pistols, and on exhortation of Kanhaiya, Satyaprakash fired at the deceased, which hit him on the face, as a consequence whereof the deceased